Okay, the final half of our, or if I should say final video for our lecture of this chapter. We left off from our last video with Roman numeral number 5. Sorry, I can't talk, but then again, that's my problem most days. Strengthening the courts. We've already covered several times, or it's been mentioned several times, that the court system was, while we had examples from English courts, we really weren't sure how we wanted them to go, and they really had not done a whole lot. They had not set any precedents from the time that Washington put John Jay in as the first Chief Justice. No landmark cases, nothing that established the power of the Supreme Court. It was basically there just to hear the appellate cases, and I don't know what cases they would have heard at that early on. It was not a common practice to always take people to court, and typically the church back then, any church, would also serve as a court in some communities because it would help settle disputes between community members. If somebody, shortchanged someone in a business deal, or maybe he sold a cow and the cow was sickly and died, and and they wanted their money back, that kind of thing. That a lot of times communities just solved these issues within themselves. They didn't look to the courts. So by the time that John Adams appoints John Marshall as the 4th Chief Justice of the Supreme Court, several other Chief Justices have been in the office, and nothing really has been done. No precedents have been set. Now, the Democratic Republicans, they did not trust the judicial branch because the judges in the courts, they were appointed by the president or by the governors of the states. They were not elected. And they felt like in order to represent the people's voice, they should be elected. However, you can go to different states right now, Howard, and you would see, like in Maryland, they have their judges run for election. But in Delaware, we don't. All of our judges, whether they are on the Justice of the Peace Court level, which is the lowest court in Delaware, or all the way up to the Delaware Supreme Court, which is the highest court we have in Delaware, they're all appointed by our governor. And the reason why our founding fathers did not want the judicial branch to be elected was they did not want them focusing on making people happy. They wanted them to focus on upholding the law. And if you fear, if we think about something like, say, the Derek Chauvin trial, there was a lot of fear with the officers in that trial. Derek Chauvin, I don't know if you would have seen it, Howard, but, of course, he's the police officer who is blamed for killing George Floyd. And he went to trial, and the news was flooded with, if there was no guilty verdict, that riots would get worse, that cities would be burned down. And there was a lot of fear of repercussions if this trial did not go the way everybody thought that it should. And if not that you would have watched it, but I did, and I could see that everybody was so worried about how the public was going to take the decisions, how they were going to respond to the decisions of the court. And who knows how much fear really played into the final decisions that convicted him. I don't know. But that's the reason why we don't want our judges elected. We want them appointed so that they can interpret the law freely without the fear of losing their job. And obviously, when people don't like politicians and the decisions they make when they go to vote in Congress, they're in fear of losing their job. They've angered the voters that put them in office. So by appointing judges, we were freeing them to do exactly what we were paying them for, and that was interpreting the law and making a fair decision for all citizens. But the Democratic Republicans did not trust them because they felt like they were not working for the people, they were working for the government. Now, John Adams appoints Marshall just before he leaves office. In fact, John Adams makes several appointments, in fact, multiple appointments, before he leaves office. He's kind of packing the court, as we would call it. He wants men who came from his own political party to sit in those judicial positions, because those positions would be for life. And that meant that a Federalist would always be making the decisions with the cases he heard. So, but anyway, before we talk about the other judicial appointments he makes, John Marshall comes to the court and he sees it as weak. And it is weak because, again, Congress had not planned on the presidency or the courts ever having any significant role in government. They were there to fill a spot and to maybe handle a few things as Congress thought was necessary, but they really weren't sure. They were not intending on it actually telling the Congress what to do. And that's what John Marshall does. And this goes hand in hand with the other appointments that John Adams makes before he leaves office. So, upon entering office, he makes some very important decisions that the Supreme Court still does today. First off, he has the justices meet in conference. What happens with a Supreme Court case, especially for the United States Supreme Court? They pick and choose what cases they will hear. Everybody has the right to file an appeal, and typically in any other court, the court has to hear the appeal. But when it comes to the Supreme Court, because of the number of cases that are appealed to them on a yearly basis, they would never be able to hear them all. So they actually look through the cases, they look through the grounds for appeal, and they choose the ones they feel like are worth their attention. And the other ones just go away. Now, when you make an appeal, you can't use that time to introduce new evidence. You're appealing because somehow the court procedure for your case, the court officers, they violated your constitutional rights. And therefore, by them violating your constitutional rights, you were denied a fair and impartial trial. So our Supreme Court, when it chooses a case, they sit in what's called en banc. And en banc means all 9 justices hear the case. And the appellate, or the person who filed the appeal, they speak first, and then the opposite side of the court case that's being appealed, they also get to speak. So let's just give an example of a capital punishment case. Okay, so the defendant is appealing to the Supreme Court to overturn his death sentence. So his attorneys would be the first to speak, and then the prosecutors who actually prosecuted the original case, they would then speak. Then the court tells them they take everything on, that they will take everything on advisement, which means they'll take what they heard, then they go to conference and they vote. And when they vote, they will always get a majority because we have odd number on the court. And so whoever gets the majority, they assign one of their fellow voters to write what's called the majority opinion. That's the winning opinion. And in that majority opinion, they write out why they voted the way they did, what merits they saw that required for that case to be overturned or remanded back to the court that it originated in. Then those, if there are any justices who dissented or said, no, we should not grant the appeal, they write a minority opinion, and that says, it gives all the reasons why they voted that no action should be taken and that the person's rights weren't violated. So those are two precedents that he set that we do today. The third precedent that he instituted was that justices do not get involved in political campaigns. And that is very, very important because, again, politics should not come into play with the interpretation of the law. And back before he took the court, you obviously had the justices that were sitting on the court favoring their political parties, which would most likely have been Federalists. They would most likely have been Federalist judges. And the last precedent that he set was that they all wear black robes. And if you've ever seen a court TV and about an American court, all of our judges wear black robes. Still do to this day and probably will for the foreseeable future. So anyway, now that he's in office, he's going to be presented with a very important Supreme Court case that's going to establish a very powerful tool for the Supreme Court to use to check the actions of not only the Congress but also the President. So in January of 1801, you have just several days before Adams leaves office, Congress passes the Judiciary Act of 1801. And in this act, it created 16 new judgeships. Then it also reduced, I don't know if you remember from the Judiciary Act that happened during Washington's term, I believe it was 1789, don't quote me on that. But the first Judiciary Act, it actually gave the Supreme Court a total of 6 justices, and we talked about how that was a problem. So in this new Judiciary Act of 1801, they fixed the problem so that now they can't have ties. There's 1 Chief Justice and 4 associates, and then they created 42 Justices of the Peace. Justices of the Peace are still in play today. They are not, however, a federal office. Typically, it's just a state that has Justices of the Peace, and depending on the state, that will determine how those Justices of the Peace are used. In Delaware, we use them to hear criminal and civil cases. So on his final night, you have John Adams sending out 56 appointments at midnight. It was his last action in office, and they became known as the Midnight Judges, and he dispatched people across the land to deliver these appointments. However, one man did not get his appointment, and his name was William Marbury, and it was left over for the following day when we had a new president and we had a new cabinet. And Thomas Jefferson had appointed James Madison to be his Secretary of State. And when Madison saw that Adams' last official act was to pack the court, he refused to release the paperwork to William Marbury. So William Marbury sued Madison for his appointment, and this went up to the Supreme Court. And this was a landmark case because John Marshall, he used great wisdom in this, and he ruled that Marbury had the right to the commission. However, Madison was not required to deliver the commission because the federal law that said that Marbury should receive this was not constitutional. And this important precedent was called judicial review. And the court still does this today when you hear about states suing the president over certain laws. And you will hear about it because of the gun control laws. You will hear about cases going to the Supreme Court, and they will take the federal law, compare it to what the Constitution says, and they will determine whether or not that federal law is unconstitutional. And it was in this case that it was the first time the court declared a federal law unconstitutional. All right, well, that concludes our chapter, and I'll be sending the test soon. Bye-bye.